The first case to come before the court this morning is Citizens Action Group versus Granger Township Board of Trustees and Mendard Incorporated. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve some rebuttal time, please let me know when you get started. I'm keeping track of the clock. It's also my understanding that the appellees have been informed that they will need to split their time, their 15 minutes time. That's however you'd like to do it. If you'd like to let me know when you get started, then I can also keep track of the passage of time for you as well. The court, we have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Andrew Karras on behalf of Appellant Citizens Action Group. Before I begin, I'd ask to reserve 3 minutes of my time for rebuttal.
Certainly.
The issue presented by this case is whether to have representative standing, that is, standing on behalf of their constituent members in bringing statutory appeals from the decisions of political subdivisions. I submit that the Supreme Court has provided clear guidance that the answer to that question is yes, and accordingly, we would ask that the trial court's judgment below, to the contrary, be reversed. Initially, where a statute provides for judicial review, questions regarding standing begin with an examination of the statute in question to see whether the statute expressly allows or limits the review being sought by the party seeking it. And so the statute in question here is Revised Code 2506.01, which authorizes review by the courts of common pleas range of governmental subdivision decisions. To quote from that statute, every final order, adjudication, or decision of any officer, tribunal, authority, board, bureau, commission, department, or other division of any political subdivision of the state may be reviewed by the Court of Common Pleas. Now, notably, none of the statutory language in that subsection, nor any of the statutory language in Chapter 2506 in general, expressly limits the range of persons who can bring these kinds of appeals. In fact, in the Willoughby Hills decision, which we've cited in our brief, the Supreme Court of Ohio expressly noted that Chapter 2506 does not explicitly address who has standing to bring these appeals, and so indicated that the standing inquiry should be determined consistent with ordinary common law understandings of standing doctrine. In particular, Willoughby Hills articulated that standing in these cases turns on the presence of particularized as opposed to general or publicly felt injuries. I would emphasize, though, that neither in Willoughby Hills or in any of the Supreme Court's decisions have they ever limited standing in these statutory appeals to individuals, or have they limited the ability of organizations to bring appeals on behalf of their membership when those members have themselves suffered the kinds of particularized harms that you need to demonstrate. And so I would submit that the Northern Woods Civic Association case, which is the case the trial court relied upon in dismissing the appeal below, which purports to hold that you can never assert associational standing in this kind of statutory appellate context. I would submit that the Northern Woods case just fails to faithfully adhere to the Supreme Court's directives. The most important precedent that I would direct this court's attention to in this case is the Teamsters Local number 436 decision. That's 12 Ohio 1861. In which the Supreme Court held that an organization that fails to bring an available statutory appeal on behalf of its membership fails to exhaust its administrative remedies and is therefore barred from bringing declaratory judgment action. And so Counsel, in Teamsters, a union, okay, yes.
Thanks. On the Teamsters case, wasn't basically the foundation of that ruling and the fact that the union had a collective bargaining group upon which to rely for its protection or the protection of its members? Isn't that a distinction between that and the holding in that case and what you're proposing here?
Sure. So I think to restate your question to make sure that I'm understanding it, Your Honor, I think the argument is something like, aren't labor unions a different kind of collective membership organization than community associations? Basically, don't unions have a direct interest in a way that nonprofit organizations don't? And what I would say in response to that is that there are cases that describe labor union standing as being derivative of membership, much like the kind of ordinary associational standing that a community group would assert. So for instance, one of the cases we've cited in our appeal in our brief is Fraternal Order of Police Capital City Lodge number 9. That explicitly describes labor union standing as representative, as bringing cases on behalf of their membership. I've also cited an example. It's the OAPSE/ASME local number 4 case in our brief, wherein the court applied, exactly the same associational standing test that you would see a court apply in the context of a community group bringing a case on behalf of its membership. So the analysis is whether it's a labor union or whether it's a nonprofit association like my client. Moreover, I would submit that the Teamsters Court was not particularly unambiguous in saying that the statutory appeal they were describing would have lied with the union itself and not just its constituent members. Just to quote from the decision at paragraph 23, the court stated, the union was not entitled to pursue its action for declared without first attempting RC 2506.01 appeal. In the next paragraph, paragraph 24, nothing would have prevented the union from attacking the validity of the EREP in an administrative appeal. And then at paragraph 25, the union failed to exhaust its administrative remedies. And so I would submit that the suggestion that really the court was imprecise in its language and was really just saying that the employees had the right to this appeal is just belied by what the Supreme Court said in that case. And so given that the Supreme Court has provided guidance that representative standing is at least potentially a vehicle to bring these kinds of statutory appeals, I would submit that it's not seriously contested that once that threshold issue is resolved, that my client in this case would have standing. That is, parties as a general matter have actions when they suffer an injury in fact, which is fairly traceable to a defendant's conduct, which can be redressed by granting the requested relief. Again, neither appellee seriously disputes that Citizens Action Group's proffered standing witness meets that test. And organizations can assert associational standing provided that at least one of the organization's members would themselves have standing. The interests of the organization are germane to the interest they're trying to protect in bringing the appeal. And neither the claim asserted nor the relief requested require the participation of the individual organizational members. Again, I don't think either appellee has seriously disputed that, provided representative standing is an available vehicle, that Citizens Action Group would be able to avail itself of that test. And so for all of those reasons, we would ask that the trial court's judgment below be reversed, that this court follow the Supreme Court guidance we've identified, that this court follow the course of action taken by the Second District Court of Appeals in the Concerned Citizens of Spring Valley case. As I would submit, those are it's a case that just better adheres to the Supreme Court's standing jurisprudence. And unless there are any further specific questions, I would my rebuttal time. Thank you.
Seeing none, counsel, you will have a full 5 minutes for rebuttal. Thank you.
Thank you.
Counsel for the appellee.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of one of the appellees, Granger Township. If it's all right with the court, I'm going to split my time with Majid Makhlouf, who represents Mendard in this case. Your Honors, the trial court correctly dismissed Citizens Action Group's administrative appeal for lack of standing. In administrative appeals, standing is a jurisdictional issue, and the Supreme Court of Ohio has told us that parties must meet strict standing requirements in order to satisfy the threshold requirement for the administrative tribunal to obtain jurisdiction. This was an administrative appeal brought under Revised Code Chapter 2506 by Citizens Action Group, which is a nonprofit organization. We know that contrary to what Citizens Action Group has argued, they actually have the burden to establish standing from the record. That's set out pretty clearly in the Hickory Street Coalition case from this court, 2004 Ohio 2246, in terms of the standard. Citizens Action Group could not and cannot establish standing in this case. The Supreme Court of Ohio, in the Shoemaker case, and also several Ohio appellate districts, including Northern Woods, which was mentioned, that's the 10th district. There's a 6th district case, there's a 4th district case that we've cited. They've all held that these kind of organizations simply do not have standing to file Chapter 2506 administrative appeals in a representative capacity. The right to appeal under Chapter 2506 is conferred only upon the person directly affected by the administrative decision. Supreme Court of Ohio has held in the Midwest fireworks case, told us that, quote, the right to appeal an administrative decision is neither inherent nor inalienable. To the contrary, it must be conferred by statute. So therefore, it's not a situation where just because it doesn't say specifically who has standing, just because they're not specifically excluded, that they must be included, as the attorney for Citizens Action Group just argued. That's not the case. You have to be expressly granted in the statute standing, which these type of organizations are not. There is no statutory provision giving another person or entity the right to file one of these appeals in a representative capacity on behalf of the person who's actually affected. In terms of the Teamsters case, Citizens Action Group claims that the Supreme Court of Ohio has somehow implicitly recognized the right to representational standing in 2506 appeals. In reality, the Supreme Court of Ohio did nothing of the sort, and the Teamsters case is highly distinguishable from this case. First, Teamsters didn't even involve a 2506 appeal, which was actually the whole problem for the union in that case. When the administrator issued an order denying the employees' grievances, none of them filed an administrative appeal. When the union later then got a declaratory judgment holding that the commissioner's retirement plan was illegal, the commissioners appealed. The Supreme Court of Ohio reversed the declaratory judgment, and they did that because the individual employees failed to exhaust their administrative remedies. So contrary to Citizens Action Group's claim, you actually read the decision, Teamsters did not hold that the union itself had to exhaust administrative remedies and therefore somehow implicitly had a right to bring one of these appeals. It was the individual employees who had to bring the appeals. The Supreme Court of Ohio did not hold or even remotely imply that a union has a right to representational standing under Chapter 2506, let alone a nonprofit organization like this. I've already described how the difference is there between a union and a nonprofit, but under Teamsters, not even a union would have that type of standing in these types of appeals. Furthermore, I would add that Citizens Action Group doesn't claim, nor can it claim, that it has standing on its own behalf to proceed under Chapter 2506. We know in this situation, the Supreme Court tells us, again, the Shoemaker case lays it out pretty well, that a person has been directly affected by a decision of a board and has asserted those rights if he, one, was a resident, elector, and property owner of the township whose legal rights and privileges were uniquely affected by the decision of the board. We know Citizens Action Group doesn't meet that. Two, appear before a township board to protest the board's action. We know that Citizens Action Group didn't do that. And three, stated his intention on the record to appeal the board's decision to the Common Pleas Court. We know Citizens Action Group didn't do that. So they don't meet standing requirements on their own behalf. Finally, I would note that Citizens Action Group is not even a legal entity in the state of Ohio, and therefore doesn't have the capacity to sue. So they actually can't bring any lawsuits. Citizens Action Group is a fictitious name that has not been registered with the Ohio Secretary of State. Therefore, under Revised Code Section 132910B, they are prevented from commencing or maintaining an action in a fictitious name until they've at least registered the name with the Secretary of State. And Your Honors, if there are no further questions, I would cede the remainder of my time to Majid, and I would just state that Granger Township respectfully asks this court to affirm the judgment of the trial court. Thank you.
Thank you, counsel.
Thank you very much, Your Honors, and to counsel on the oral argument. I'd like to highlight 3 points for the court that I think are very important. Number one is the distinction between original actions and appeals. I know we casually sometimes use the term trial court, but the trial court in this case, in administrative appeals, is the administrative agency. The Common Pleas Court sits as an appellate court, not as a trial court. So in looking at standing principles, standing case law, we have to look to case law on appeals, not case law to institute an original action. You're looking at it in the same case as if somebody had a trial before the Summit County Court of Common Pleas or the Medina County Court of Common Pleas, and somebody's appealing to the 9th District. Who can appeal that decision? We're doing exactly the same thing in the administrative context, where the administrative agency was for, I'm using the term trial court loosely, it's acting in a quasi-judicial capacity as the trial court, and the Common Pleas Court is the appellate court. And I think much of the case law cited by appellants is for institution of original actions. There's complete confusion of the case law and standards for lodging an appeal from a judgment as opposed to initiating the very first action as the party. And clearly, there is no such thing as a representative capacity to file an appeal, and the case law on this is very clear. It doesn't mean that a representative group is out of options. Typically, what happens in these situations, the neighborhood groups would provide funding for one of the property owners who is impacted to file the appeal. The appeal is filed in the name of the property owner. The organization finds funding for it. They file amicus briefs before the court. They may even try to file a motion to intervene as a permissive intervention, so long as the primary party who is directly impacted is the party lodging the appeal, and then they could try to impact the decision in that court. But the idea that a party who doesn't own property is a voluntary group somehow has the ability to just jump in and file an appeal on behalf of other parties who may be impacted is just simply not how, this is not an original action where somebody's trying to get a declaration or anything of that nature. Only the parties to the case can appeal that case. The second issue is the Teamsters case, and I happen to have the luck or burden, I guess, of having served as Cuyahoga County's law director, so I'm very familiar and dealt with 37 collective bargaining units and negotiations into the wee hours. Quite frankly, labor unions would beg to differ with the argument being advanced by appellant's counsel. In the labor context, there is a long history of the National Labor Relations Act, the collective bargaining law that vests union with rights. There's a collective bargaining agreement. The union, to represent those employees, it's an exclusive relationship. It's, if you notice the name of the case, it's not the Teamsters against Cuyahoga County. It's local number 436. It's the specific collective bargaining unit that has the collective bargaining agreement with Cuyahoga County, in which Cuyahoga County recognized the union as the exclusive representative of that group of employees. Literally, in the labor context, there is jurisdiction. Different bargaining units have different jurisdictions. We use those terms. And for a grievance to be filed by the employee who is represented under a collective bargaining agreement, the union is the entity that files that grievance on behalf of the employee. That's how collective bargaining law works. To compare that to a citizens group that may have interest, by all means, they can, that is very different in terms of the labor law. And I think even in that context, the Teamsters case, it's very critical to review that case critically, because I think it's correct that in the very first paragraph of the opinion, the court identifies, and it literally in quotations says collectively the union. The appellants in that case were the employee themselves and the union. So there were two parties. The employee himself was a party, which we don't have any individual here as the party, just the organization and the union itself. And the court defined both of them collectively as the union. But then in articulating the test that the court was measuring, in paragraph 9, what the county argued was that the sanitary division employees were required to exhaust the available administrative remedies. It was that the county never argued, nor did the Ohio Supreme Court hold, that the union had to file the 2506 appeal. Of course, when the employee files the grievance before the county, it's filed through, when the employee files it, it's filed through the union, but it's the employee that would be filing that grievance, and that was the test that was before the Supreme Court. In paragraph 20, the court said, we first looked to what administrative remedies were available to the union represented sanitary division employees. So, and again, in paragraph 23 that was cited by appellant's counsel, the court says that the union argued that there was an exception there for employees to have to file the appeal, because the appeal in that case would have been futile. And in paragraph 24 itself, when it talks about the appeal, it's very clear that it's talking about the employees filing the appeal. But of course, a represented employee in filing the appeal would be represented by the union in filing the appeal, because that's the exclusive remedy through which the employee can lodge its appeal under the collective bargaining agreement, and with the union being represented as the exclusive representative of those employees. So we're comparing day and night, and honestly, just nothing to do with it. The other issue in terms of the Willoughby case cited by appellant's counsel, Willoughby case was the city itself appealed its Board of Zoning Appeals determination on a variance question. And the court said that yes, the city can appeal its own Board of Zoning Appeals decision, but keep in mind, what is a variance? A variance is seeking an exception from the strict compliance of a city's codified ordinance. So you had a decision by the city that was being challenged before the Board of Zoning Appeals through a variance process that was decided adverse to the city. So the city, as the real party in interest, appealed to the Common Pleas Court saying our Board of Zoning Appeals got it wrong, reverse it. That's what Willoughby stands for. It doesn't stand for some third party coming. It wasn't the municipal league coming in and filing an appeal on behalf of the city of Willoughby. It was the city of Willoughby itself filing an appeal of an adverse decision that it got on its own code being interpreted against it. And the last point that I'd like to highlight with the court is, I think the appellant's counsel has repeatedly made the reference that we somehow concede that the person who submitted an affidavit before the court somehow has standing. We've never agreed to that. That is an issue that's never been litigated. The way that happened is when they filed the administrative appeal, there was no person associated with the notice of appeal. We filed the motion to dismiss. In the briefing for the motion to dismiss, the court closed the briefing at the opposition briefs, and that affidavit was filed with the opposition brief. And our position all along was the court never needed to reach that question, not that that person has standing to bring the appeal themselves. If you look at that affidavit that it was actually submitted, in Ohio, affidavits have to be based on personal knowledge. That affidavit expressly on its face says based on her knowledge, information, and ability. And then when it talks about the impact to property, it's my belief that the property would be impacted. Not that there is an actual impact to the property. It's about beliefs and opinions as to what can happen, which is not how affidavits are based in Ohio. And the property impacted is about a mile away. So, or allegedly impacted is about a mile away. But again, the common pleas court never needed to reach that question, and this court didn't need to reach that question. My alarm just went off, so
Yes, so did mine. Thank you, counsel. Attorney Karras, you have 5 minutes for rebuttal. Also, I wanted to let you know that sometimes your feed is, at least to me, is operating a little slow. So we can hear you, but I guess what I'm saying is you have 5 minutes. Please don't talk super fast because your feed is kind of gets a little bit behind every now and again.
I will do my best to be as deliberate as possible.
Thank you.
Thank you. So a couple of points in rebuttal. To speak to the language in Shoemaker, because I think what Shoemaker was misstated a little bit in argument. Shoemaker was, like the Teamsters case, a ultimate by the Supreme Court, essentially for the same administrative exhaustion problem, that the appellant in that case was a contiguous landowner whose property they said was affected by a land use decision. And the Supreme Court held, well, you cannot bring a declaratory judgment action in this context because you had standing to bring a 2506 appeal. And so I think the language that a person must be directly affected by the decision has been a little bit misunderstood by the Northern Woods line. In fact, language was the effect of that language was to expand the class of people who can and should bring 2506 appeals, as opposed to declaratory judgment actions. That was not in the context of the case itself, limiting language that, again, expanded the range of people who are properly supposed to bring this particular statutory vehicle. And in Willoughby Hills, again, as we pointed out in our brief, the Supreme Court specifically walked back that language in Shoemaker, noting that there is absolutely no reason to limit a municipality's standing through the use of a, quote, directly affected test. And so I would submit that the Northern Woods case, which was decided before Willoughby Hills, and the cases that follow Northern Woods lead in that regard in maintaining this quote unquote directly affected requirement, such that there is no such thing as representative standing in these statutory appeals. It just is not just does not faithfully adhere to what the Supreme Court has articulated the standing requirements in these appeals are. Counsel for the township made a procedural point about the burden to establish standing from the record being ours. It's worth emphasizing that the administrative record is actually not produced at the request on the motion of the township. And so I would submit that it cannot be the rule that it is the appellant's burden to demonstrate standing from a record which the court has expressly granted permission need not be produced. To respond to another point that the township raised, so it is true that association, that said, as we've cited in our brief, revised code 1745.11 explicitly allows unincorporated associations to sue and be sued. I think Valentic's standing affidavit clearly demonstrates that the group is not a trade or a for-profit association, and it's operated, for its membership's common nonprofit purposes, such that it qualifies under Ohio law as an unincorporated nonprofit association. Again, I would just regarding Counsel for Mendard's point about what the Teamsters case says and does not say, the point that the Supreme Court made a party definition early on in the case, I'm not quite sure that leads to the conclusion that counsel has suggested, because if you were to take every instance of quote unquote the union appearing in the opinion and replace it instead with, as the Supreme Court defined that party, the union and member Kevin Lesh, that certainly does not divest the union of the ability to bring the appeal that it says should have been brought by the union. Again, just to quote directly from the opinion, nothing would have prevented the union from attacking the validity of the EREP in an administrative appeal. That wasn't coupled by any sort of analysis about how procedurally an individual member might have filed a grievance. It wasn't coupled with any sort of analysis about whether these employees were in privity with the union or not. I think the most natural and straightforward and clear reading of what the Supreme Court said in the Teamsters case is that this was a remedy that would have properly belonged to the union had they sought it, or had that.
Counsel, with that, I've allowed you to go a little over time because I allowed counsel for the appellees to go over time a little bit, but we have reached the end of our time for oral argument today on this case. And I want to thank each of you for your presentations today and for agreeing to proceed via video oral argument. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.